Good afternoon, everyone. Welcome to the Appellate Division First Department. I'm going to call the calendar in a second. You all are familiar with the spiel, so you know only ask for the time that you think you need. It's not a perfect world, so don't ask for the time that you would need in a perfect world because this is not a perfect world. Okay, People versus Jermaine Gomes. 4-2 and 4. Brigham versus New York City Loft Board. I'm sorry, how much time? 3? Excellent. Yes, respondent? 3-3. Brianna C. is submitted. Sukkanen versus Pinellas. 3-2-3. People versus Greg Donchik. 4-2-4. Igbara versus 24 West Food Corp. Is there an appellant? Did you wish to submit? Okay, great. Thank you so much. Submitted. West Capital versus Bocce. Submitted. Sedgwick versus New York City Department of Education. Submitted. People versus Liz Rodriguez. Submitted. Oh, we're on a roll here. National Interstate versus Interstate Indemnity. Oh, you broke it. Okay. 4-1-4. Talos Capital versus 257 Church. 7-2-7. Vela versus Fairpoint Companies. Submitted. Pesman versus Bloomingdale's Inc. Is there Bloomingdale's here? 5-1-5. NS versus Frankenhoff. Submitted. And I just so you're clear, if we have questions of you, we will certainly ask them of you, regardless of how much time you've actually been allotted. Okay? First case, did I miss something? Oh, you're looking at me. He's looking at me. When the court officer looks, especially the sergeant looks at me, I got to figure something happened. People versus Jermaine Gomes.
Good afternoon, Your Honors. May it please the court, my name is Sarah Chaudhry and I'm counsel for appellant Jermaine Gomes. While at the hospital for the birth of his son, Mr. Gomes was arrested for criminal trespass. After the police arrived...
Well, it was a little bit more than that. And it's a tremendous experience to have the birth of a child. But I think it was a little bit more than that in terms of what the allegations were, in terms of the trespass. I mean, he was asked to leave the hospital a couple of times. There was an allegation that he may have urinated or something in one of the rooms. So it wasn't a little bit more than a simple trespass?
Yeah, so Your Honor, the allegations that you're referring to are allegations that the prosecution did not submit as a part of its suppression papers at all. In fact, when Mr. Gomes requested a bill of particulars, the prosecution responded by saying the VDF and the felony complaint provided all of the information that was necessary.
Well, it says, according to the complaint, the security guard told the defendant that he had to leave the hospital, but the defendant refused, right?
So, Your Honor...
And also, but the gist of it is we're talking about the possession of the counterfeit bills, right?
Well, I think first we have to go back to what you just alluded to, is what does the felony complaint actually state? It appears that, there was an understanding that in order for Mr. Gomes to be excluded from a public place, such as a hospital, there had to have been a lawful order that was communicated to him, personally communicated to him, by someone who had the authority to exclude him or someone who was the owner of the premises. The felony complaint doesn't quite get us there. All the felony complaint tells Mr. Gomes at this juncture is that someone who spoke to a member of security who spoke to the police.
The individual works for security at New York Hospital, is a custodian of the hospital, observed defendant inside the hospital, and according to the complaint, told the defendant he had to leave the hospital, but the defendant refused.
The felony complaint doesn't state that this individual, who's the alleged custodian, actually asked Mr. Gomes to leave. And it also doesn't provide any information about him.
Who would qualify as the alleged custodian?
Well, per the statute, the message to leave has to be personally communicated by a custodian.
Any security personnel qualify as a custodian as far as you're concerned?
Well, I think that's something that we would have to, that should have been brought about at the hearing.
Did
Now,
he ever
for us to just
deny that
simply
he was asked to leave? I'm sorry, counsel, I keep
sorry.
interrupting you, but did he ever deny that he was asked to leave by security?
He was asked to, no, I don't deny that he was asked to leave by security.
No, did the defendant ever deny that?
No, but what he did allege, given the bare bones submission of the prosecution, was that he was behaving lawfully at the time of seizure.
No, well, yeah, but we're talking about two different things now. So you're talking about the basis or the predicate for the arrest and then the search. Is that correct?
Yeah.
Okay. So you're stating that there was nothing in the complaint alleging that he had been told to leave the hospital?
No, what I'm saying is that the complaint doesn't really get us there. The complaint simply says that someone who's a custodian who only saw him in the hospital, it doesn't detail any of the events that this alleged person saw. And if you read the complaint, it doesn't say that this custodian actually asked Mr. Gomes to leave, right? In order for him to have been properly lawfully excluded.
Also, that's going to the merits. In terms of the information that was in the complaint, did the defendant make a specific denial of trespassing?
Given what the prosecution has asserted, Mr. Gomes' assertion that he was in the hospital lawfully, which he would be if he was not properly excluded, sufficed to create a factual dispute. I think one thing that we don't want to lose sight.
I think the answer to that is no, right? Because basically all the defendant says is, I wasn't doing anything unlawful. And that's not enough. At the very least, the defendant knew he was charged with trespass.
Well, respectfully, Your Honor, we have to assess and we have to look at his allegations in reference to the prosecution's allegations. They haven't really given us much,
There's a charge of trespass. It cannot be any easier than to say I was not trespassing.
Well, what Mr. Gomes would have had to say.
What he said was that he had not been engaging in any unlawful or suspicious conduct at the time of the search and seizure. He did not say that he was not trespassing. He didn't say that he had not been told to leave the hospital. He did not state that he didn't defecate in one of the examining rooms. All he said was that basically his behavior was innocent. And again, as my colleague stated, at very least, he knew he was charged with trespassing.
Well, the prosecution didn't tell us that a custodian actually asked him to leave, right? So he would have been lawfully in the hospital.
The complaint says, the complaint alleged that an individual known to the district attorney's office that works for security at New York Hospital and is a custodian of the hospital observed defendant inside the hospital and told the defendant that he had to leave the hospital, but defendant refused.
But that's not what the felony complaint states. It doesn't state that this individual actually communicated that to Mr. Gomes, which is the requirement under the statute. It seems like the way that this felony complaint was written was with an understanding of what
I'm looking at the felony complaint. It says, the security guard told defendant he had to leave the hospital, but defendant refused.
Where does it say that? Because it simply says that this custodian observed Mr. Gomes in the hospital, that Mr. Gomes was told to leave, but by who, we don't know.
Oh, so you're saying because it does not say that this individual told him to leave, that we don't know who told him to leave?
That's accurate. We've seen many felony complaints where they actually make the actual assertion, where they would say, Mr. Gomes, the opponent officer spoke to the custodian of the hospital. The custodian said—
And is it your argument that based on this perceived lack of information that your client could not allege that he was not trespassing?
Your Honor, yes, and there's two things. I know that my time is up, but I also wanted to get to the second point. One is that because the prosecution itself failed to set forth facts that would demonstrate that the statutory requirements had been met here, that Mr. Gomes, all he really had to allege was that he was behaving lawfully, which he would be if he wasn't properly excluded. But as to my second
somebody
point,
told him to leave the hospital. And so, at the very least, since someone told him to leave the hospital and you're arguing that the complaint doesn't tell us whether it was, I can't pronounce the officer's name, Wojciechowicz, whether it was him or whether it was somebody else, some security guard told him. So your arguing is that we don't know whether it was Wojciechowicz or someone else, but the defendant still did not allege or state, I was not told by anyone that I had to leave the hospital.
Well, that's not really what he had to state because, all he had to say was, I was behaving lawfully, and he was behaving lawfully because he wasn't properly excluded by the person with the requisite authority. He doesn't have the facts.
But he never
to say-
said that. All he said was, I was behaving lawfully. He did not state anything else. And again, I'm not really following you on your argument that, there was nothing, that he didn't have information known to him as to exactly what the allegations were. But you can think about that on your rebuttal. We'll address that.
Good afternoon, Your Honors, and may it please the Court, Andrew Chung for the people.
So the defense basically argues that under our decision in Jameer Sneed, there should have been that the defendant was not on proper notice as to exactly what he was told, who he was told by, and also whether or not this individual was an agent of law enforcement or not.
Yes, Your Honor. So with regards to the argument in Sneed, I'd like to first start off by stating that this argument in particular is unpreserved, but even if we were to reach it on the merits, Sneed is inapplicable here because in Sneed there was a genuine issue over whether or not the security guard was an agent of the state, and that is not a particular argument that we are facing today. So the primary legal question that we are here today to discuss is whether the defendant, in his omnibus motion, pleaded sufficient facts to warrant a suppression hearing. And it's clear that given the particular factual circumstances of this case that he did not. Now, as this court knows, New York courts looked at three so-called Mendoza factors in order to determine whether a defendant has set forth sufficient factual allegations to warrant a hearing. In the interest of time, I'd like to focus on two of these factors, the face of the pleadings and the defendant's access to information.
So why is it not sufficient to say that he had not been engaging in any unlawful or suspicious conduct at the time of the search and seizure?
Well, Your Honor, as this department has held in cases such as People versus Esteban, generalizing global denials of criminal wrongdoing are simply insufficient to create issues of fact that warrant a hearing.
Counsel, based on the information that was available to the defendant in this case, would it have been sufficient had the defendant said, I was not trespassing?
We do not have a... So what I would say to that is that we think that there would probably be a little bit more needed, especially given the fact that the defendant had ample access to information. So if you look at the totality of the information that the defendant had access to, there was quite a bit. So for example, the criminal court arraignment minutes, in the criminal court arraignment minutes, the defense counsel themselves stated that it was a security guard who told the defendant that he had to leave by midnight and that the defendant was upset and questioned that directive against him. Defense counsel also stated that the defendant waited outside with security for the police to arrive. And even if I know the defense in their reply brief mentions that, or they make the argument that the criminal court arraignment minutes shouldn't be relied on, even if this court weren't to take those into consideration, the felony complaint and the voluntary disclosure form also provided the defendant with ample access to information. The felony complaint alleged that the defendant knowingly entered and remained unlawfully in New York Hospital, despite being told to leave by a custodian, and the voluntary disclosure form noted that 2 eyewitnesses had made point-out identifications of the defendant. Given that the defendant was here for the entirety of the incident, it's unclear why he was unable to make specific factual allegations in his omnibus motion.
Well, does it matter if it was Officer Joseph Wojciechowicz or Officer Jessica Boyle or some other officer who actually told him to leave the hospital?
I believe those officers that you're mentioning are members of the police who arrested him. To the rest of my understanding, based on the record, the people who initially excluded the defendant from the hospital were hospital security guards.
And so was the defendant, was that known to the defendant?
Well, we only have to go off, to answer that question, we can only analyze what the record on appeal indicates. And the record on appeal during the criminal court arraignment minutes, defense counsel themselves stated that it was a security guard who had excluded the defendant. If they're able to make such factual assertions in the criminal court arraignment, it's unclear why they were unable to make similar arguments here. And I see that my time is up, but if I could briefly conclude.
Yes, go ahead.
So given that the defendant was here for the entirety of the incident, as I briefly mentioned before, it's unclear why he's unable to make specific factual averments now. Indeed, he makes more specific factual allegations in the defense brief and the reply brief, even though nothing has presumably changed between now and then, nor has the defendant's access to information increased. For these reasons, it's clear that the lower court was warranted in denying the defendant's request for a suppression hearing. If there are no further questions, we would rest on our brief and ask that you affirm. Thank you.
Thank you.
Okay. I mean, one thing that I wanted to point out is that the prosecution's reliance on the criminal court arraignment minutes in and of itself demonstrates the paucity of its papers. And one of the things that I think that is being lost or obscured in this discourse is that the burden on the defendant to create a factual dispute is explicitly mediated by the information that's relayed by the prosecution. This court, as well as the Court of Appeals, has stated that even seemingly bare-bones assertions, such as perhaps the ones that Mr. Gomes has made, are sufficient when the prosecution itself has failed to set forth key facts. Now here, what my adversary has done is engage in a lot of inferences and suppositions. He's read the felony complaint to state that the custodian was the individual who asked Mr. Gomes to leave when that's nowhere to be found. At no point did the prosecution, which is one of Mr. Gomes' other contentions in his motion to suppress, at no point did the prosecution provide any information about the witnesses that it allegedly relied on to effect Mr. Gomes' arrest. Instead, the prosecution invited this court to yet again engage in inferences and suppositions and say, well, we can just infer that the information that the police heard and relied on was accurate. Even if Mr. Gomes was aware that security asked him to leave, that says nothing about what the information the police heard, who they heard it from, was it reliable, was it accurate. All Mr. Gomes needed to do was create a sufficient factual dispute. And that's something that he needed to create in reference to what the prosecution had provided. Here, they fell woefully short. Even if this court, even if the lower court had determined that the factual allegations that Mr. Gomes had set forth were insufficient, it should have exercised its discretion here to order a MAP hearing because it had already ordered a Huntley hearing. And contrary to my adversary's assertions in his papers, the MAP and the Huntley hearings would not have necessarily involved different witnesses or facts, but yet again, we're being asked to infer. The motion to suppress stage is not the stage at which we should be engaging in these inferences. It's at the stage where we're supposed to be deciding, will the prosecution be able to meet its burden to show that Mr. Gomes was lawfully arrested and obtained his first and only conviction because of this alleged trespass?
Thank you.
Thank you.
Brigham versus New York City Law Board.
Good afternoon, Your Honors. I am Thomas Brigham, the petitioner, appellant, and the appellant in this appeal. This appeal addresses a wrongful issue of a temporary certificate of occupancy at the subject premises, where the issuance of this TCO is a public record, a final certification determining and ordering recognition of Jaffe respondents' lawful completion of all required fire and safety legalization construction, that the legalization has been lawfully achieved. And here, the TCO was issued wrongly, and all parties agree that it should not have been issued. The central question raised here is, what is the lawful remedy for correcting wrongfully issued and falsely filed certifications? And when a determination is made in error through dereliction and deception, once that error is known to the issuing agency, does the law require or does the law allow that the prior wrongful certification be revoked when it is known to be the fruit of an invalid and illegal campaign perpetrated for personal gain by respondent Jaffe? What happened here was false certifications, false inspection reports were provided in order to support the TCO. The false inspections were discovered and the inspector was permanently banned for life by the disciplinary committee on basically the same day that the temporary certificate would expire, or not they were discovered, but they were, or the renewal was denied in a Department of Buildings objections order. So the TCO was denied renewal for false filings on the same day it expired, and the the respondents here and the general administration of this was, well, we don't have to revoke that because it just expired, so it's moot. And that is not the case. It is not moot. The loft law explicitly makes a distinction in the loft board rules between failures of a landlord to achieve fire and safety legalization and TCO, and is distinct from failure to maintain the TCO. And the respondents, Jaffe respondents have, can and have made the argument in related proceedings and this proceeding that they merely failed to maintain it because it was invalid for 6 months and did not fail to achieve it, and therefore they would no longer be subject to the increased scrutiny that applies on getting a TCO. And now it's just a maintenance issue, and it does not require the heightened scrutiny and procedural process involved in achieving it. So central to my appeal here is everybody knows, everybody admits that that TCO was wrongly issued, and it does make a difference whether they are whether they never got one or whether they are failed to maintain one. And since it was wrongly issued, I'm arguing that they never got one and never should have had one, and therefore it should be revoked.
Thank you. You have time on rebuttal. Oh, you don't have any rebuttal, sorry. But thank you.
Thank you.
You can just have a seat.
Good afternoon, Your Honors. May it please the Court, Diana Lawless on behalf of the City Respondents, which is the Loft Board and the Department of Buildings.
So is that TCO still in existence?
The TCO hasn't been in existence since April 2019. This appeal is much narrower than what Mr. Brigham has argued and what he's argued here today and what he's brought in his papers. The only order on appeal is the denial of leave to renew that didn't bring forward the original orders, which Your Honors have seen from our brief. It was the subject of a prior transferred order and appeal that was dismissed for failure to perfect. So with respect to the denial of the motion to renew, for which the standard of review is abuse of discretion, there's no evidence that Mr. Brigham provided to the court that could change its prior determination of dismissal. The new evidence could not change the two legal grounds on which it originally denied the petition on the question of this temporary certificate of occupancy. As Your Honor, we just noted, the TCO expired in April 2019. It's moot because it's no longer in effect. It stayed moot because DOB had not issued another during the time period which he made his motion. And in any event, any evidence that Mr. Brigham brought could not get to a vacatur of a temporary certificate of occupancy anyway, moot or not, because it is a discretionary determination of the Department of Buildings, and new facts wouldn't change that legal conclusion. And I think we do dispute what Mr. Brigham just said about the TCO should never have been issued. On this record, it was that it was not renewed after an audit of the DOB. But there's not, because we made a motion to dismiss on those legal grounds, there was no other information in the record on the first motion related to this. So if Your Honors have no other questions, we ask that you affirm.
Thank you. Thank you both. Suknanan versus Pinellas.
Good afternoon, Your Honors. Nicholas Bruno on behalf of the appellants. It is our contention that the motion court erred in granting defendant's motion for summary judgment for two reasons. First, the motion court incorrectly determined that defendants had met their prima facie burden. Second, the motion court erred in failing to consider the report of plaintiff's expert, Dr. Beach, and the MRI report, thereby—
So did any of the your experts in their reports establish or state that there was a causal relationship between the accident and the plaintiff's injuries?
Yes, Your Honor, Dr. Beach did. And that was on page 631 at the conclusion of her report.
But is that report in admissible form?
It is our contention that it is, Your Honor.
All it has is a notary stamp. It has no other language indicating that it was sworn to?
That's correct, Your Honor. Under the case law of this court, it's presumed that the notary has acted appropriately absent any contrary evidence. And there was no contrary evidence that the notary acted against the rules in notarizing this report.
So it means that the person that signed it was Dr. Beach. But does it actually mean that the contents of the document are true?
It is our contention that it is.
It is your contention that it's truth, but don't you need an attestation clause? Because you may believe that it's true, and I understand that you would, but how would a court or someone making a determination come to the conclusion that it is in fact truthful and true without an attestation clause?
You're correct, Your Honor. And even if it is inadmissible, it's still our contention that the defendants failed to meet their prima facie burden, in which case it would not need to be considered. And to that point, the report from Dr. Fayette is insufficient because it fails to explicitly address plaintiff's claims of exacerbation.
Well, defendant's expert says that the radiologist, right, stated that the spine revealed degenerative and pre-existing conditions not causally related to the accident. And also that it noted, I think in 2016, the plaintiff had also been in another accident. So that was put forth by the defendant. So now the question becomes, what are you now putting forth to rebut the evidence put forth by the defendant? And that's when we get to the failure to have admissible reports.
Well, one of our contentions on appeal is that because Dr. Fayette didn't explicitly address the exacerbation claims, that it's not sufficient to disprove or satisfy the prima facie burden with respect to the exacerbation claims.
The report of your radiologist is not affirmed and does not even causally relate whatever impression he says he finds in the films to any accident, not the first or the second.
The Dr. Fayette?
No, your doctor from Stand Up MRI.
Oh, yes.
Dr. Katzman.
That's correct. That's correct.
So Dr. Fayette says not causally related. Your doctor doesn't say anything.
We do also have the testimony of plaintiff himself, who said that he did not experience any pain prior to the May 2018 accident. So there was no pain stemming from the 2016 accident.
And then we have an additional, I guess, hurdle that you have to overcome, and that is the extensive gap in treatment. There's no explanation as to why there's such a long period of time between his final treatment and then the treatment again in 2021. So where's the explanation for that long gap in treatment?
That's not something that we address on appeal.
Thank you.
Thank you.
Good afternoon. May I please
Counsel,
the-
can I ask you, how do you respond to your adversary's statement that your expert did not address exacerbation?
First of all, the claims of exacerbation are simply boilerplate allegations in the complaint and the bill of particulars. But he actually did. He stated that they're not
You're speaking of Dr. Fight,
Dr. Fight, yes,
right?
Your Honor.
He said,
They're degenerative in nature, chronic, not traumatically induced, and, not causally related. So that addresses the issue of exacerbation.
so you're saying degenerative, using that term basically explains that it is not an exacerbation of a prior injury from an accident.
Correct, Your Honor. Correct, Your Honor. And in terms of
Well, he said that the disc bulges were not post-traumatic, and he said that the MRI revealed pre-existing degenerative changes.
Correct. Well, that means all of the injuries essentially did not exacerbate any injuries or.
Could you read pre-existing degenerative changes to possibly mean an exasperation?
I'm sorry?
Could you read pre-existing degenerative changes to possibly indicate some type of exacerbation?
No, the question here is, you've got to read it in its entirety. It's not just pre-existing. The issue is also not causally related to the accident. And in terms of the evidence submitted in opposition, it did not raise any genuine issue of fact. Dr. Beach's report was unsworn. It's essentially a notarized letter. A chiropractor must submit an affidavit. They cannot just submit an affirmation. And the report submitted did not swear to the truth under the penalties of perjury. And also, the records from Good Samaritan Hospital were not in admissible form because they were not certified. And the only evidence in submissible form was the deposition testimony of the plaintiff, which only relates to subjective complaints. Here, when you're determining whether there's a serious injury under any of the categories that plaintiff alleges, you have to have objective medical evidence. And even if it did, his testimony indicates that he had no significant limitation, no consequential limitation. He was back to work, driving 12 hours a day his taxi. The only other thing that he saw was, he was unable to walk too far. He was not confined to his home or bed at any particular time. So that, coupled with the lack of treatment, all in its totality, established that the defendants had met their prima facie burden, and the plaintiffs did not, and especially they never addressed the gap in treatment given the length of time after, between the last treatment and Dr. Beach's report.
Thank you.
Thank you.
I'd like to focus on the sole issue of the degenerative comment in Dr. Fate's report. I would like to direct the court's attention to its decision in Scott v. Posis, which is 194 83rd 454 from 2021. The first footnote states that defendants failed to establish that the limitations noted by the plaintiff's expert were the result of a prior accident or prior injury as opposed to exacerbations caused by this accident.
So, counsel, when the defendant's doctors say it's degenerative changes, right? That shifts the burden to you to say something about it. You have to say something about it because the defendant's doctor, Fight, says these are degenerative changes that are not connected to the accident. What did you put in to dispute that?
Nothing, Your Honor.
Okay.
Thank you.
Thank you. Thank you both. People v. Greg Donsick.
May it please the court, my name is John Finnegan. I am the counsel for the appellant Greg Donchik. Your Honors, Mr. Donchik appeals from the decision of the Bronx County Supreme Court, which was a grant of the people's motion to depart upward from an otherwise presumptively level 1 Sex Offender Registration Act classification. The court in the second
Counsel, do
page
we
of
know
its
what the basis was for the court's finding that defendant admitted his collection contained over 100 images? Do we know where that came from?
We don't, Your Honor, and it's a spurious fact. This report was prepared in the middle of the pandemic. I don't know if that had anything to do with it, but the basis of the record here were the documents that emanated from the criminal prosecution in the Southern District of Florida. There's nothing in those documents concerning a Dropbox account. There's nothing in there about 100 or more images. In fact, when he was arrested some months after his active use of this pornography website had ended, he only had in his possession 15 still images and 12 videos, which is not indicative of a large collection, which was one of the bases that the people raised as justifying upward departure. But there's nothing in the record to support that, Your Honor. The court below determined that there was a basis, or relied on, rather, the June 2012 position statement that the Board of Sex Offenders Examiners put forth, which is not a binding document on any court. It's just a statement of position. But the court, again, relied on that explicitly, that there were more than 100 images. I would remind this court that in People v. Gonzalez, you reduced a level 2 classification to a level 1 classification based on more than 100, or approximately, I think the decision said, of 150 images. Again, there was not, he was only found in possession of a small handful of contraband images. The paid subscription clearly is a problem, but he was only active on that website for 15 days. As I said in my opening and in my reply brief, I think that all of the parties misread the record here. If you look at the federal affidavit, it is very clear that he was a subscriber for 35 days on the contraband website, but he was a Comcast subscriber for a longer period of time. So he could get Netflix or HBO for 2 years, but he was only active on this.
Just for clarity, you mentioned 15, and then I think you self-corrected to 35. It's 35, correct?
Yes, it is. I'm sorry, Your Honor. But beyond that, Your Honor, the other part of the court's, I mean, that was a main part of the court's determination that it should upwardly depart. I would also like to point out that in Gelati, which is a Court of Appeals case, they determined that the fact that persons who are prosecuted for passive viewing of child pornography are generally not considered dangerous or eligible, or not eligible, but inclined to recidivate. And that by itself is a factor that is of a kind or to a degree that...
Wait, are you saying that the Court of Appeals made that finding? That child pornographers are not? I thought that's what you just said. Okay.
I'm sorry, to clarify then. No, people who passively view it, not creators of, which are a separate...
No, but again, the question is, are you saying that the Court of Appeals stated that when you're a passive viewer of child pornography, you're not going to reoffend?
No, what they're saying is that that is a factor that the court can take in determining departure, downward departure.
That it's passive?
Yes, correct.
Okay, that's fine.
Yes.
I understand that.
Okay. With that,
Thank you. You have time on rebuttal.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Kalani Brown on behalf of the Bronx County District Attorney's Office. Your Honors, we respectfully request that this Court uphold the Soar Court's decision granting an upward departure from a level 1 to a level 2 risk in this case.
Ms. Brown, where is the information obtained that this defendant possessed over 100 images
Your Honor, that information was located in the case summary in which the board said that the defendant made an admission that there was over 100 images, as well as the defendant's admission in the SORA hearing on page 27, where he indicates that it was 100 images. And so, Your Honor, the conduct, the egregious conduct and nature of the defendant's actions involved having a paid, subscription.
Counsel, do you concede that the SORA court erred when it said that the defendant was active on the website for a year and some months, when in actuality it was 35 days?
Yes, Your Honor, there's a possibility that that could have been misconstrued based on the statement of paragraph 7 and 8 in the affidavit, which conflated the Comcast subscription with the last date of activity. And so the affidavit states that he was active on the site or created the website on November 15th, 2017. He last accessed its website December 20th, 2017.
But when you said created, I think you mean he registered on the site.
Yes, registered, Your Honor, my apologies. And so he last accessed that account on December 20th, 2017, but the account was still active up until he was arrested July 18, 2018.
But there was no information that he was on that specific website, right? He could have been watching Netflix, for all we know.
Yes, Your Honor, that is correct.
Let me ask you something else. How come the people didn't seek a 30-point assessment under Factor 5 for a child victim under the age of 10 when the report states that the defendant had an image of a man masturbating to a penis of a baby boy? So why did you not seek 30 points under Factor 5 if that was the image?
Yes, Your Honor, the people relied on the case People versus Perea, which stated that you have to have a description, the actual name, the age of the child in the description of the video. And so unfortunately, it did say little baby boy, which in and of itself indicates that it was someone less than the age of 10. However, it did not say the exact age. And because the one video we did have explicitly stated 13-year-old boy, then we were able to assess 20 points under that.
So are you saying that based on that video, that image of this baby boy, that you couldn't establish beyond clear and convincing evidence that this child is less than 10?
That could have been established at the hearing, Your Honor, but the prosecutor did not go that far to present
Well, had the prosecutor gone that far, we wouldn't be here, right? Because then it would be 80 points and a presumptive level 2.
Yes, Your Honor, that could have been a possibility.
So I want to get back to the 100 images. You're stating that during the hearing itself, the defendant stated that he had more than 100 images?
Yes, Your Honor, and if I can turn your attention to page 27 of the SORA hearing, the defendant or the defense indicates that no one actually fixed the number of images that the defendant was in possession of when he was arrested, but it is around 100 plus. And so based on that admission, that's why the SORA court used that statement to base its decision on granting the upward departure to level 2.
What about the conviction itself? So this was in Florida. Is there anything in the paperwork or anything that was charging documents, et cetera, that were forwarded to New York, which would indicate that it was 100 plus images?
No, Your Honor, we don't have any information to that effect.
So the 100 plus, we just have the representation at the SORA hearing and what else?
And the case summary.
And the case summary is based on what?
On the pre-sentence investigation reports, the record that we do have on appeal, but the case summary also says it's not limited to that information. So there could have possibly been an admission, but we don't have a concrete piece of paper that says this was the admission on this particular date.
Thank you.
Just to be clear, Your Honor, the defendant never testified at the SORA hearing. What counsel's referring to is the argument that was made at the SORA hearing, which was an even-if argument that I made, which was that even if there were 100 images, it's not a vast collection, which was what they were basing the motion for upward departure on. Further, there was no pre-sentence investigation in this record anyway. There were only 2 documents that I'm aware of, which were the affidavit in support of the search warrant and the factual proffer that was made in support of the plea. But there was no pre-sentence investigation that was part of this record.
So where was the information obtained from?
Your Honor, I honestly don't know. There's nothing in the record to support it. I mean, I made the statement that counsel is referring to at the hearing, but I was arguing that even if there were 100 images, it's not enough for the court to depart upward. That factor, the number of images, it translates to number of victims. It's taken account of in the risk assessment instrument, and the basis for a departure has to be something that's not taken account of appropriately in the risk assessment.
So you're saying that at the hearing, you didn't say how many?
No, I'm not saying that. I'm saying that I argued even if.
But did you say at the hearing it was 100+ images or not?
Your Honor, I don't have the transcript in front of me.
But let's assume that you did. That would be an admission, right, by your client, or you're representing your client. I assume you wouldn't say that if you didn't have a good faith basis for
Judge, I have no good faith basis for it. If I said it, it was transcribed incorrectly, or it was misunderstood, as I misstated the Gelati precedent a moment ago in the heat of the argument. The other thing I would like to say also, Your Honor, is that the case summary itself is not sufficient as credible hearsay if it's contradicted by other credible evidence in the record. And the record does state in numerous instances that when Mr. Donchik was arrested, he made no statements to law enforcement. And the statement in the case summary purportedly is based on an admission that he made at or about the time of his arrest, which is, again, not in the record. Thank you. I would ask that the lower court be reversed.
Thank you. National interstate versus interstate indemnity.
Good afternoon, Your Honors. May it please the court, Brian Barnes for the plaintiff's appellants. I think the key in this case that's getting overlooked by my opposition is the standard that we have to apply, which is when you're trying to determine if notice was provided within the time period that it could have been, you have to look at, one, was there a lack of knowledge of the available coverage by the additional insured? And two, if there was, were reasonably diligent efforts made to provide notice under the circumstances. And here, if you look at the entirety of this record, you can see that reasonably diligent efforts were made. In opposition...
Did you have a copy of the certificate of insurance?
There is no dispute that there was a copy of a certificate of insurance in New York Crane's possession that was provided to them as part of the initial Crane rental agreement.
Did you ever call up the insurance company that was listed in that certificate of insurance to find out whether or not they were still the insurer of Broadway, I forget the name.
Broadway Concrete.
Broadway, yeah.
Yeah, no, there's no evidence in the record of that. But what they did instead was, if you looked at that certificate of insurance, there was a broker listed on it, who brokers are the ones who issue certificates of insurance as a matter of information only, right? So the broker who issued that certificate of insurance was contacted multiple times by New York Crane to figure out who has the subsequent coverage in this case. What they also did was they asked the insured numerous times. If you look at the first tender letter that's sent, again, no dispute that we had a certificate of insurance, right? The very first tender says, hey, we have your certificate of insurance. We looked at it. The policy period has expired by the time of the loss. Please tell us who has the subsequent coverage. There would have been no reason to do that if we had known, which is why the first aspect of the standard, the lack of knowledge, has been met. And I would like to direct...
Counsel, did you put in affidavits by the people who made all those phone calls and inquiries? Because I didn't see them.
There are two affidavits in the record. One is from counsel who was representing New York
forget
Crane.
about counsel. Did you?
Well, Your Honor, I would point out that counsel representing New York Crane in the underlying action, Wilson Elser's office, was the one who was leading the investigation.
I'm just asking, you're saying that we made a lot of efforts So, but what I didn't see was you said a lot of phone calls were made, I didn't see any affidavits from anybody who did that. I'm just trying to figure out, did you put that in?
Yeah, I think, and I can't speak to everything that's in every affidavit that's in there, of course, but I think if you look back at the affidavit from Glenn Firth, who's counsel, and then Adam Martin.
No, but that was the guy who said the letter, oh, here's the, right? He's the guy who said, here's the old policy, where's the new policy? That's covered. But then you made a statement, and then we made a lot of phone calls, and we was that anywhere factually in the record?
Yeah, I think if you look at the Firth affidavit, there's calls by counsel from his office that were made. Those are discussed in there. There's also emails that are attached that reference phone calls being made.
Emails.
So there's a litany of evidence. There's emails, there's letters, there's the affidavits that describe the efforts that were made. And what I would point out to the court is if you look at, there's a case we cited, it's a trustees case. It's a New York County Supreme Court case, I'll admit. It's from 2005. And if you look at what the court looked at in that case in trying to figure out if the efforts made were reasonable, the efforts that were made in this case go above and beyond what that court found to be reasonable as a matter of law, right? In that case, the argument that was made in opposition was, look, you knew who the insured was. You only asked the insured's broker. Why didn't you ask the insured? Which the court rejected. They said, no, you don't need that to establish that your efforts were reasonable. In this case, New York Crane went beyond that, right? They asked the broker who had issued the certificate of insurance. They asked the insured itself multiple times, and the insured told them, hey, we've put our broker on notice. We'll assume they'll get back to you. If the named insured under the policy, Broadway, couldn't even figure out who its insured was, when they told New York Crane, they told them the wrong insurer. How is the additional insured supposed to be in a position to know who the subsequent coverage was with when the named insured itself couldn't even figure it out?
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Kira Fitzpatrick, brief formality. I'm here to present my colleague, Timothy Jabor, admitted to the bar of the state of New Jersey, with the court's permission to permit him to participate in today's appeal for oral argument.
It's granted.
Good afternoon, Your Honors. Timothy Jabor, Tressler LLP, with permission on behalf of the respondent cross appellant. Simply put, there's no dispute that, as counsel acknowledged, that the COI that was issued in connection with the Crane rental agreement, which was the subject of the project, was in the possession of New York Crane at the time the original suit was filed. There's no dispute that notice wasn't provided until almost over 2 years after the original lawsuit was filed. So as a matter of law, the notice was late. What's left here is whether or not there is a reasonable excuse for failing to put on notice interstate indemnity. And we
Is it a reasonable excuse that they said to Broadway Concrete and to its broker, Global Associates, fellas, let us know who your insured is?
There's no doubt that efforts were made. However, if you look at both the Lafarge case that is a third department case, as well as the trustees case that was cited by National in the brief, the import of both of those cases is that the certificate of insurance was utilized in that case to identify the proper carrier. Here, we have heard nothing with respect, and I think counsel acknowledged that there was no effort to contact interstate indemnity, which was listed on that certificate of insurance. Admittedly, that certificate of insurance was for a prior policy year. However, as Mr. Iasola testified during his deposition, there was no requirement to update the certificate of insurance as the Crane rental agreement was extended, right? The Crane rental agreement was for original period.
But counsel, how would your adversary know that? I mean, that's not something that your adversary would know.
Certainly, they had the ability on behalf of the putative AI to inquire of the AI who had the certificate of insurance. When they took the steps to reach out to both Broadway Concrete and the broker and received no response, the reasonable next step, if not taken at the initial step, the reasonable next step would have been to reach out to the liability carrier that was specifically identified on that COI. The worst that could have happened at that point in time was, as would have happened in the trustees' case. They received a response that said, no, we're not the carrier of record here. That was not done. It's respectfully submitted that
As a matter of law, we should find that? I mean, really? Don't you think there's enough here to go to a jury, to let the jury decide whether its efforts were reasonable?
respectfully, under the Lafarge case and under the trustees, given the import of the certificate of insurance, we do
No,
not
because
believe
that certificate of insurance, unlike the other cases, was not a current certificate of insurance, right?
admittedly, it was not a
So
current.
that's a little bit different.
It is different, but it's important that that information was and always in the possession of both New York Crane as well as their carrier national. And
But perhaps it wasn't up to date, right?
the certificate of insurance indicated the prior policy.
Yes.
Correct,
Right.
absolutely. There's no dispute about that. But the import of, I think, again, both the Lafarge case and the trustees is that those steps were taken to identify, even in trustees, they reached out and were told that it's the wrong information. That wasn't done here. So as a matter of law, we do not believe the steps that weren't taking, it was unreasonable. And if I just may briefly touch upon, because I don't believe, the wrap-up exclusion, which the appellant here indicated that the lower court implicitly indicated was not applicable by the trial court, it wasn't addressed in oral argument, it wasn't addressed in the trial court's opinion. It's the position of the respondent that that wrap-up exclusion is applicable and bars coverage in the first instance. As my time is up, unless there's questions from the panel, I will rest on our papers.
Thank you very much.
Thank you.
Very briefly, Your Honor, I'll hit 2 points. The Lafarge case came up a lot in the briefing, and if you look at what the Third Department said in that case, they specifically say, a reasonable possibility the subject policy is involved. Not the insurer, not someone else, the subject policy. There's no dispute in this case that the subject policy, the one actually in effect at the time of this loss, was not listed on the certificate of insurance and was not known to New York Crane. Second, quickly, I think the trustees' case goes to show that not taking one step that you otherwise could have, right? In trustees, they talk about you could have asked the insured directly who they had coverage with. And the court said, you didn't do that, but we're going to find as a matter of law that your efforts were reasonable to provide notice. Here, within 1 week of the time that the record shows that New York Crane knew who the coverage was with, the tender was made within 1 week. That notice should be reasonable and timely as a matter of law. Finally, the wrap-up exclusion, there are multiple reasons why this does not apply to bar coverage here. Chief amongst them is it's been waived, it's untimely asserted. There was never a written disclaimer issued on it. Even if the court wants to consider whether 3420 doesn't apply in this case, which we would submit it does with respect to a denial to New York Crane, I would invite the court to consider its own decision in the GPH Partners case, which was cited in our reply, but not addressed in the reply brief submitted by Interstate. That case can be found at 8783D 843, and the same exact argument was made in that case. It was a wrap-up exclusion, it wasn't asserted, and then the argument that 3420 didn't apply was not made until appeal. And what the court did in that case was they found that the carrier trying to assert the wrap-up exclusion had waived reliance on it pursuant to 3420, and the court in its decision rejected all other contentions that were made, and Admiral had in the briefing, which we directed the links to, I have the Westlaw citations if the court would like them. In the briefing, Admiral tried to argue this is a carrier versus carrier 3420. The court in its decision specifically rejected that argument by rejecting their other contentions.
Thank you very much. Thank you both. Talos Capital versus 257 Church.
Good afternoon, Your Honors. Robert Smith for the appellant. I'd like to focus, if I may, on two questions. Sorry. The first is whether the privilege ruling below is correct, and secondly, the reasons Your Honors might consider directing reassignment of the case. On privilege, the two documents we're mainly concerned about are in the little volume of the record, the confidential volume. I think it's obvious from a quick look at them that they're typical of confidential attorney-client communications. One is a thread in which the lawyer is advising a client about his exposure to liability under the deal documents. Another is a lawyer putting into layman's language the gist of the deal.
So, counsel, may I ask you, because it's unclear to me from the record, are there only two documents that were to be produced solely on the at-issue privilege, or were there other documents that were? I'm talking about only, because I couldn't figure it out.
I'm having some trouble figuring it out too, Your Honor, but they've all been produced because we didn't have time to get a stay.
But I'm saying
and these are the two we care about clawing back.
But there were a number that were required to be produced, and I couldn't tell which ones were just on the basis of at-issue privilege and which were on the basis of sent to third parties. They weren't privileged because of other things. Is there anything in the, I couldn't tell.
I mean, I have the same problem you have, Your Honor. I don't think the judge was totally clear, but
so
they
then
can,
whatever it is,
they can keep everything except those two documents.
There is some subset that was required to be produced just on the at-issue privilege, correct?
Oh, yes. There's no, as to these, there's certainly, I don't see any serious claim.
But there were other that were also required to be produced because, for example, there were CCs to people who are not attorneys or not whatever. They didn't, the court found that they didn't, I just want to make sure that there were some that were on one issue and some that were on other issues and some that could have been on all 3 or 4 different bases.
I think that's correct, Your Honor. In fact, as to the third parties, and we're talking about what the judge ruled in the October 12 hearing and the order appealed from, as to the third parties, we kept saying to the judge, no, all we want to do is redact them. We never meant to withhold the stuff that went to third parties. I'm not sure he ever accepted that, but we did keep saying that.
Or for ones where the court found that it was business advice and not legal advice.
Well, I don't think in the October 12 order he found any of those. He did in his re-argument order.
Right. Okay.
He did say that. And that would. I think in his re-argument order, he thought that applied to one of the documents here. I just think that's wrong. I think it's classic attorney-client communication.
Okay.
Now, what the court held as to the two documents in its October 12 order was that the privilege was waived because the documents went to the heart of the dispute. That's the essence of the holding. The heart of the dispute, as Your Honors know, is that the timing of the payment.
I think I was definitely on the last appeal panel for that, right? And the question was when was the money due?
Right.
And the two parties had a different interpretation of the document.
Yes, and that is still true, Your Honor. And the court held rejecting the primary position of both parties. The court held the agreement was ambiguous. As to the holding, which I think was the central holding of the court, that the privilege was waived because the documents go to the heart of the case, there are two answers. One, they don't, and the other is it wouldn't matter if they did. I think you can look at the documents and see there's nothing in there about when the payment is to be made. I think the judge committed the error that it's easy to make when you're not immersed.
Counsel, more fundamentally, the relevance to an issue in the case does not negate attorney-client privilege, right? That's your primary argument, right?
Absolutely, Your Honor. If I'm on trial for murder and I confess to my lawyer that I'm guilty, well, that goes to the heart of the case, but that doesn't destroy the privilege. You're of course. That's why I say they don't go to the heart of the case, but it wouldn't matter if they did. So I submit the court rather clearly erred, and in the re-argument order, the judge, in the course of denying re-argument, came up with some other theories. We never had an opportunity to address those because they first appeared in the re-argument order. If we do address them in our brief, I think they're all
Counsel, what I would like to get to is what was the fraud on the court? I was concerned about the alleged fraud on Supreme Court as well as the fraud on the appellate division.
Yes, obviously, and we're very concerned about that too, Judge. It was a very serious accusation that the judge made. I've spent some time trying to figure out what it was supposed to be because but when I look back at the transcript, and I did really yesterday, I think the judge answered the question in the transcript, and this is from page 20, which is the very end of the October 12th conference, page 20 of the record. And this was after I had asked for a little more time, and he said, "No, I'm not giving to you because I think there's a fraud in the court." And I say at this point, that he's ending the conference, I say, "Thank you, and and you will not indulge me to say that I take exception to the accusation of fraud on the court and to explain why." The court, "No, I really think that this should properly be briefed at this point, and I'll view it in the papers, and the record will stand as it stands." And then the court continues. But it is clear, but it is very clear, based on the review, that the argument that the documents were ambiguous and that they meant something else was belied by the express understanding of the lawyers and the business deal, as codified in 7474. So that's what the judge thought the fraud was. And 7474 is the second of the two documents in the little confidential.
Yeah, I saw that. But so the argument was, or the decision was that somehow these documents did not actually state what you proposed, what you stated?
The argument, as I understand what the judge is saying, and what he undoubtedly deeply believes, is that these documents proved that there's no basis for arguing ambiguity, that he was right the first time, Your Honors were misled, and that was fraud on the court. And that raises a host of problems, but I'm out of time.
Thank you.
Your Honors, may it please the Court, Stephen Meister for the respondent. There are two critical points here that I think are being missed. The first is that what was asserted below on the merits was not a different interpretation. The lawyer didn't say, "I read this document differently." He said there was a specific conversation in 2013 when these documents were signed. He named the persons who were in attendance at that conversation, which were both the appellant and a lead negotiator for the lender. And he said they agreed that even if the $10 million payment were missed in 2018, it became $20 million, and there was what I'll call a bad boy carve-out.
Counsel, this is what's set forth in the transactional lawyer's affirmation? What you're recounting now is what you put in, right?
This is in the opposition to the summary judgment motion, which dehors this record. But in my opinion, Your Honor, one cannot assess the propriety of the ruling on the privilege without understanding that there's essentially a mischaracterization of how this parole evidence, this testimonial parole evidence is being used. It's being used to advance an oral agreement. Now, we believe that testimony is false. The second point, which is made clear in the judge's 13-page decision on re-argument, which dehors the record but is critical and I think should be considered, and this is NYSIF 281, the judge writes, "Documents are significant not only for what they do say, but also for what they do not." That's page 12 of that 13-page decision. Going on, the fact that...
No, counsel, that's not before us, right?
But
what you're talking about right now is not in our record. Let's go through our record, right?
Okay.
Because we can't, honestly, we just can't.
Well, that is part of the
can't
problem,
consider,
Your Honor.
Well,
that is part of the problem,
So let me ask you this. Is it your position that everything that, all of counsel's advice on this transaction is at issue?
No. Not at all. Your Honor, in 317, page 317 of the supplementary record here, there is an email chain from November 28th, 2013.
What is your position on why the at-issue privilege, why the privilege is waived because
The privilege is waived because in, for example, that November 28th correspondence, when the appellant queries his counsel about the guarantee obligation, the response is devoid of any reference to there being different timing for the corporate guarantor's pledge responsibility, which is undisputedly in 2018 at the 5-year mark of the loan.
And you're saying that created an waiver of the at-issue privilege?
No, Your Honor.
So again, what is your basis for saying that there is an at-issue waiver here?
Okay, because in opposition to the summary judgment motion, the way that the testimony of the deal lawyer was used is they literally quoted from his deposition transcript in the opposition to the summary judgment motion, saying that there was a conversation and that there was an agreement reached in this conversation. Under controlling law, which I'm happy to address, if I need the emails that show that that conversation is false testimony in order to impeach Mr. Chris, then I am entitled to that, and one cannot advance that factual testimony and then deprive me of impeachment
It
evidence.
seems to be more of an omission than an admission.
That's why I started with the remark, and Justice Scarpula pointed out correctly that it's in the re-argument decision, but unfortunately...
No, but your argument now, and what you're arguing is, again, what's before us on appeal, again, seems to be more of, an omission than an admission. You're saying that you need that for rebuttal purposes or to show that there's an inconsistency, but the real inconsistency appears to be because it wasn't mentioned.
No, it's both, Your Honor. In the first email from November 12, 2013, which is 319 of the record, there's a specific reference by the lawyer that when the $10 million obligation is triggered, that triggers the $20 million obligation. The $20 million obligation includes the guarantee obligation. So there's an affirmative statement in that email that impeaches the veracity of the testimony, which we contend is false, about this conversation. Separately and additionally...
How does that impeach it? Because it doesn't specifically say, and by the way, the triggering event is this?
Because
that's what waived the attorney-client privilege?
The waiver, okay, first let me unpack that. It says the $10 million pay down at the end.
I know what yes. How does that?
He's saying the $20 million obligation.
So, counsel, please, just let her ask the question.
Right. Let me just ask you, how does that create an at-issue waiver?
The at-issue waiver doesn't arise from the email. The at-issue waiver arises from the way that the deposition testimony is being used to advance their interpretation of the agreement. That deposition testimony is testimony of a conversation at which an alleged agreement was reached. The emails...
So between whom and whom? Who was at...
Between the lender and the guarantor.
So I assume that one party is going to say that isn't true, and the other party is going to say it is, correct?
But in addition, that's right, but in addition to one party...
How does that create an at-issue waiver?
Because, okay, John Doe versus United States, Second Circuit, quote, "It would be unfair for a party asserting contentions to an adjudicating authority," which in this case would be that this agreement was reached in 2013, "to then rely on its privilege to deprive its adversary of access to material that might disprove or undermine the parties' contentions. In such circumstances, the rule is more aptly described as one of forfeiture rather than waiver. That's the Second Circuit that was cited favorably by the Court of Appeals in People versus Kozlowski. That's on Respondent's Brief, page 43, and by this court in Re New York City Asbestos 109 AD 3rd 7. And in Bilzerian, U.S. versus Bilzerian, a Second Circuit case, the privilege cannot be used as both a sword and a shield. So the waiver, Justice Scarpula, or the forfeiture arises from the use of the testimony to advance a factual proposition that is, at a minimum, undermined. And lastly, I want to point out, because you had some questions about this, there were 81 emails reviewed in camera, 81.
Let me just ask you, why can't you impeach by the other guy who said it wasn't true? Why isn't
I can and I intend to.
So then why would that create an at-issue waiver? Those cases that you're talking about is where there is no other possibility of challenging that statement. But here you have two non-lawyers in a conversation. One says it happened, one said it didn't. So they can impeach each other.
If the lawyer is communicating with his client in a matter which both affirmatively and by omission impeaches the credibility of his account, controlling law holds that results in a forfeiture of the privilege for that limited purpose. In any event, there is an email, you're correct, there's an email in this exact same time frame where the lender says to his lawyer, I get a $20 million guarantee in 2018. And the lender's lawyer just makes one correction, it's only if there's a bad boy act. But doesn't say, and it would be 5 years later, which is obviously what the lender's lawyer would have said were the testimony of the guarantor's lawyer truthful. But our point here, and I think, look, you're right about the record, Justice Scarpula. There was a 13-page re-argument decision. There was a decision on the recusal motion. There's 81 emails, of which only 2 are in this record, 2. And so the issue of, these sua sponte rulings, you can't assess, honestly, the propriety or fairness or reasonableness of the judge's statements about a fraud in the court without looking at the totality. One of the things he says in the re-argument decision at footnote 4, I think it's on page 7, is that that not one of the 81 documents reviewed in camera, not one supports the appellant's.
The problem, counsel, is that when you make, as a judge, and when you're rendering a decision, and you make such a statement, either you say, you have to say the basis for your determination that there's a fraud on the court. So you either say, and that's based upon the totality of the record, or you say it's based on A, B, and C. There has to be something that we can look at, or the appellate division can look at, to see exactly what the basis for that statement is.
Well, that's why, it's clarified very substantially, Your Honor, in the 13-page re-argument decision.
So it has to be clarified or stated in the actual decision when you're actually making that statement. That's the way it has to be. But thank you very much.
Thank you, Your Honor.
I just want to make clear, Your Honors, how remarkable Mr. Meister's answer was to the question, what's the fraud on the court? He said the fraud on the court is not in the emails, it's in the deposition testimony. The deposition testimony had not been given at the time the judge accused us on the record of fraud on the court. The deposition testimony.
He said it was a totality of the record. It was everything taken.
It's about the totality, including parts that didn't exist yet, apparently, which I think is going a little far.
Well, what is your response to the argument that based upon the deposition testimony now, they should be able to use the emails because the emails are inconsistent with the deposition testimony?
Well, once again, it doesn't. If they said what he said, it wouldn't, for the reasons that Justice Moulton suggested earlier. It wouldn't make a difference. It wouldn't create a waiver. But in fact, they don't impeach.
But then you're tying
anything.
your hands, right? Because now they can't use information, which they have, to show a possible inconsistency.
They never should have had it. It's privileged. But that's the privilege. If they were, first, it's not impeachment. There's absolutely no inconsistency between the documents. And indeed, Mr. Meister, the argument Mr. Meister keeps making really is there's not if the testimony were true, these documents would say something about it. There's really no inconsistency. His theory of inconsistency is a play on the word triggered. The document says that X event triggered the guarantee. It did trigger the guarantee, perhaps, but that does not mean that it triggered it for immediate payment. And my view of the relevant document is that if the lawyer had thought that the government that it required immediate payment, it would not have said we have a guarantee. It would have said we have a right to immediately collect the money, which is different. They did have a guarantee. They didn't have a right to collect the money.
So, counsel, let me just ask you, when you're in your opening argument, you talked about reassignment, but you've subsequently made a motion to recuse, correct? Okay, so that has a whole record to it.
That's true. I would, yeah, and the reason that only this order is here now, Your Honor, is that the case, we wanted to get at least the privilege issue before Your Honors, before we either have a trial or summary judgment, which I think are going to be quite imminent. I do think, Your Honors, I make no claim that I have no right to rely on anything outside this record. I do think Your Honors can, in considering the administrative question, look at anything you want, including the re-argument decision, which makes, I thought, premature credibility findings, which are disturbing, and the ethics opinion, which talks about a possible complaint by the judge to the grievance committee. And I think it's for Your Honors to decide. I have no right to ask for this relief as a matter of right, but it's for Your Honors to decide whether it would not be better for another judge to hear.
Is all of that in the motion to recuse?
No, I think we made the motion to recuse before those things happened, Judge. Well, one of them, the last one, was he asked the ethics committee whether he was obligated to report us to the grievance committee for making the motion to recuse, because he thought that was an inappropriate motion to make.
Well, again, that's not before us, right?
It is certainly not in this record. When you make an administrative decision, you look at whatever you like. We can't tell you what to look at and what not to look at. Thank you.
Thank you. Last case for argument, Pesman versus Bloomingdale's.
Okay, may it please the court, I'm Anna Pejman.
Pesman, excuse me. I pronounced your name incorrectly.
No, it's actually, you can say it's Pesman or Pejman.
Okay.
It's Persian, so you can do either way. If it's okay with you, I think I'm going to forsake my rebuttal because my arguments are pretty straightforward. Although arbitration is it's a very difficult thing to overturn, and it's very difficult to vacate an arbitration award, there is definitely bases here in the record and cogent arguments that the arbitrator, was impartial. He didn't hear pertinent evidence. He failed to apply the law properly. And as the 10th Circuit has coined the phrase, willful inattentiveness to precedent, which I think is very apropos of his actions. And although it's been said that the arbitrator can make mistakes in applying the law and doesn't have to hear all the arguments, that's quite different than rendering a decision that flies in the face of certain precedent that I cited to in the brief. So just to wrap up, I think that this is a case, an exceptional case. It's a case of egregious impropriety. And based on all these, all these arguments, hearing pertinent evidence, Section 10 of the FAA, it was very, very vital that he heard the evidence, and that's why the protocols, the arbitration protocols are in place, especially vis-a-vis labor disputes, is that those items that respondents' representative produced as an attachment to a reply in a summary judgment motion, it should have been produced early on, given the condensed nature of the arbitration proceeding. That's one basis, and then evident partiality is, it's clear that he did not correctly apply the law, and it was done affirmatively and in bad faith. That's the second basis. And the last basis is just the objective facts that show that he was not impartial. So there you have it.
Thank you.
Good afternoon, Your Honors, and may it please the Court, Gabriella Tremont for Respondent Bloomingdale's. As this Court is well aware, there are two statutory mechanisms pursuant to which an arbitration award can be vacated. The first is the Federal Arbitration Act, Section 10, and the second is CPLR, Section 7511. Respondent's position is that whether the petition to vacate is viewed under the FAA or the CPLR, the outcome would be the same, and that Justice Bluth's determination to confirm the arbitration award should be affirmed. New York courts have been very clear that judicial review of arbitration awards is extremely limited, and the party seeking to vacate the award bears the high burden of proof in doing so. I know this court is well aware of the four grounds for vacating an arbitration award under each the CPLR and the FAA, so I, in the interest of time, will not recite them. But according to New York law, it is clear that an arbitrator's interpretation of the evidence and their authority is to be accorded substantial deference, and a court will not overturn an arbitration award unless there is no support underlying the decision. In support of her main appellate brief, petitioner makes several arguments. And in her main appellate brief, she largely fails to attribute the arguments to certain grounds under either the FAA or the CPLR. And our position is that even if she did do so, she has not demonstrated a viable basis for vacating the arbitration award. It bears emphasis that the merits underlying the award are not at issue here, and this court should not examine the merits and substitute its judgment. But in any event, I will attempt to very briefly address a few of the arguments that she just made. So the denial of the ability to present evidence, she briefly touched on the failure, I believe, of her to submit a surreply at the motion for summary judgment stage. She correctly claims that respondent for the first time submitted a piece of evidence in its reply in further support of its motion for summary judgment. However, the record is clear that respondent submitted that for the very first time to respond to an argument that was made by petitioner in her opposition to the motion for summary judgment for the first time. So we do not view that as a proper grounds for vacating the arbitration award. To the extent she argues that Arbitrator Chang manifestly disregarded the law in any respect or misapplied the law, she doesn't delineate how the law was misapplied. And in our position, again, that's not a proper basis for vacating the arbitration award. With respect to partiality, again, very briefly, She touches on a few arguments in her belief that arbitrator Chang was partial against her, for example, in disparaging her as an attorney, but in many instances, she doesn't cite to a specific statement or issue that is clear and convincing evidence of partiality or biases. At this juncture, I would say that petitioner is merely trying to relitigate the underlying merits of the arbitration, and again, that is not appropriate at this juncture. Arbitrator Chang heard the evidence, he read the papers, he issued a 20-page final award which analyzed each of her claims, and he offered a more than colorable basis for his decision. So we ask that this court affirm the decision of Justice Bluth to confirm the arbitration award.
Thank you. Are you waiving your rebuttal, or would you like rebuttal? Okay. You have 1 minute.
Well, nowhere in their opposition brief did they ever refute the statement by Chang that in the past he would get hotel rooms and not charge the payer. So motive clearly is an issue in this case. Saving time and money for the party that pays the arbitration is clearly an improper motive. When you have two sides paying for arbitration, I would venture to say that it may not be as big of an issue if the arbitrator is looking to save time and money for the parties, two parties. If that, jives or if that squares with the arbitration rules. But when you have one party, and then I'm gonna let you go, one party paying for arbitration, the risk of not being impartial is a higher risk, especially when you have somebody saying that in the past, this was his course of action. There is a difference between the Federal Arbitration Act and the CPLR in New York. And I've cited to case law, and there's a New York case law. The FAA allows you to go through with the arbitration process as long as you object to the impartiality or you make objections. It's kind of hard to make a motion to recuse an arbitrator when there's no provision in the arbitration proceeding and it's towards the end of arbitration. The impartiality mounted in increments, and I just don't subscribe to the argument that under the FAA, if you continue with the defect in the arbitration, that you don't have recourse afterwards. And
Thank you. Thank you both.
Thank you very much. Oh, I'm sorry.